Let me put it bluntly. When you enacted the law, you did not, in the debate in Parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind.
Decriminalizing homosexuality, your very act of decriminalizing homosexuality does contemplate that therefore people who belong to the same sex would be in stable marriage-like relationships, encounters, but as something more than that, not just a physical relationship, but something more of a stable emotional relationship, is the existence of two spouses who belong to a binary gender necessary, or the requirement for a relationship of marriage? You're really leading us on the path of statutory interpretation.
That's true.
Statutory interpretation, not based on text, not based on intention,
Go beyond.
not based on original intention, not based on purposive teleological
So
interpretation.
you're really asking us to read into the statute the expression spouses for really man and woman.
So
And
does the
therefore,
underlying thrust of SMA exclude your lordship's reading or insertion or understanding of that construct? Is the
because
case?
your principal premise is that when the legislation was enacted in 1954,
Yes.
the object of the legislation was to provide a form of matrimony for people who are not falling back on their personal law of marriage.
Absolutely, absolutely.
Right? And not,
Special categories.
you are giving Parliament was intending to provide an avenue to people beyond your religious, the religious governance of marriage, so to speak.
There was also an aspect of endogamy.
Yeah.
Yes.
There was
Yes,
an aspect of endogamy
yes,
which
yes.
we cannot ignore.
Yes, yes, yes.
So
yes.
it was an all-enfolding kind of a legislation.
And it cut across so many spectrum because it was intended to
And
be a very
therefore,
special
after
category.
1954, in the last 46 and 69 years, our law has really evolved to recognize the fact when you decriminalize homosexuality, you also realize, well, these are not just one-off relationships. This also comprehends a stable relationship.
Because you go back and
Therefore,
say, yeah.
by decriminalizing homosexuality, we have not just recognized fleeting relationships between consenting adults of the same gender, right? We have also recognized implicitly, therefore, the fact that people who are of the same sex would be in stable relationships. Now, if the object of the law in 1954 was to bring in its fold people who would be governed by a matrimonial relationship apart from their personal law, then surely that law is capable of being broadly read according to you, so as to take into account more stable relationships.
Let me put it bluntly.
The same sex as well.
Let me put it bluntly. When you enacted the law, you did not, in the debate in Parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind. You may not have considered them.
That makes no difference.
You may
Another
not.
way which you are perhaps propounding is this provided a framework, but that framework is of the concept of marriage. The
Exactly.
concept of marriage transcends
As it
contemporary understanding to
It's an evolving,
comprehend-
dynamic concept.
to
Absolutely.
comprehend an evolving idea of
Dynamic,
marriage.
very dynamic concept.
So used in a constitutional sense, it only provides a framework.
Framework.
And that framework is broad enough to, assimilate later developments.
I
So it
don't want to.
transcends the existing.
I don't want to sound well. That is really well put with respect. The provision of a framework which departed from the existing framework already, because it took care of personal laws. Now, in that framework, are you cast in stone, or are you in an evolving dynamic picture? And can the underlying thrust and your lordship's institutional capacity sustain it? This is the summary of the whole Ghaidan principle applied to SMA.
And from the perspective of institutional capacity, we have to ask ourselves whether we would be doing something which would be fundamentally contrary to the scheme of the statute.
You also have to make a new statutory scheme.
Yeah, exactly. Would the
New
court be
statutory
rewriting the entirety of the statute? Would the court really be making policy choices which is for the legislature to make?
Lordship.
So long as we don't straddle that line which divides policy from the judicial process, you're still within the fold of it.
I'm very grateful, which is why they have put this second test. The
But
first test was
equally, I
enough.
think the impact of
the
Ghaidan
line.
is to liberate the court
Yes.
from the very, very traditional approach
Yes.
of looking at everything as a matter of statutory interpretation. Therefore, purposive interpretation also falls back on interpretation of that statute and the language of that statute.
That is important, Mulus. That teleological and purposive also, which is supposed to be in
I'll
advance,
play again-
falls back.
I'll play a little bit of a spoiler. Ghaidan provided the framework for the introduction of a of a law in 2004, which assimilated all these developments, which led to the blessing of statutory recognition of these kind of partnerships. And then it took another 10 years for these to be recognized as marriages. So that too is an aspect which we will have to keep somewhere in mind.
Absolutely, Manoj. Your Lordship, that's the difference. It's a holistic thing Your Lordship keeps in mind. Ultimately, the feel of the case is only Your Lordship will, that is, nobody can be identical. Nobody is saying
Because
it.
I'm sure if you go to Gaidan and if you follow it up, there could be other cases which have followed
Now,
that.
so I've now time, given my
Dr.
time.
Singhvi,
I've done this.
Dr. Singhvi, I think, I mean, looking at India constitutionally and socially as well,
Yes.
we have already reached the intermediate stage, right? The intermediate stage postulates that by decriminalizing homosexuality, your very act of decriminalizing homosexuality does contemplate that therefore people who belong to the same sex would be in stable marriage-like relationships.
Marriage-like is the operative word.
Right, marriage-like relationships.
Live together.
Because the moment we have said that it's no longer an offense under Section 377, therefore we necessarily contemplate that you could have a stable marriage-like relationship between two persons who do not treat these as chance encounters, but as something more than that, not just a physical relationship, but something more of a stable emotional relationship, right?
Societal.
Which now is an incident of our constitutional interpretation. Once we have made that, we have crossed that bridge, then the next question is as to whether our statute can therefore recognize not just marriage-like relationships, but relationships in the relationships
On the
of
contrary,
marriage.
I started by saying it's a logical move in the same direction. It is, in fact, little done, vast undone. Your Lordship is now getting to cover that territory because to merely decriminalize is one category. Otherwise, it does, in an actual daily sense, remain a shell.
Requires us to,
Hollow
of course, it
shell.
requires us to redefine perhaps the evolving notion of marriage, because is the existence of two spouses who belong to a binary gender necessary, or the requirement for a relationship of marriage? Or has our law now progressed sufficiently to contemplate that the existence of binary genders may be, but is not necessary for your definition of marriage?
And Malas, to that comes in the intersection of the Article 14. You in your counter and everywhere else are underlining immeasurably the vital importance of marriage, to which I bow down. But that vital importance of marriage is restricted to one category.
Expanding that definition, are we then trenching upon that area which Gaidan excludes to the judges?
That is, Malas, in case your Lordship has got to stitch a whole cloth, which only a statute can do. That ultimately will be your Lordship's call. I don't think at all, which now, Josh will just note on the side, para 44 has some other cases similar to Gaidan. I'll not read them. I don't have time to read them. Para 44 of my submissions. I'll now come to that 3 or 4 queries arising under the SMA, and then come to the notice of objections regime.
But in a way, Dr. Singhvi, I think what happened in the UK is really, in that sense, not in that. I was just talking to Justice Call, is not really in that sense in all fours with what happened in India.
Not at all.
The HRA in the UK was intended to enforce treaty obligations under the ECHR.
Yes.
Right? For us, we've always had the overarching principles of the Constitution, which lie above.
That's the irony. We are a for sure, Manoj, with respect. I'm saying on interpretation. This case is cited and the article is cited only for an approach to interpretation.
And, we are not here using the Constitution or utilizing the text of the Constitution to either read down a statute or to strike down a statute. That's one element of the impact of the Constitution. The other thing which we are doing now here is expanding the meaning of a statute in the context of constitutional guarantees. And in that, you are saying be liberated from the bare text of the Constitution or the notion of parliament.
The first part of what I argued yesterday was dignity, non-discrimination.
See, in the backdrop of constitutional interpretation, we have never used the originalist doctrine, right? India, unlike say what Justice Kalia said, we have never regarded ourselves as bound by an originalist interpretation.
Kalia is an extreme example.
In which case, Dr. Singhvi, if we have never been bound by an originalist interpretation of the Constitution, should we be bound by an originalist interpretation of the statute,
statute.
itself,
Correct.
which is in that sense subordinate to a constitution?
And he, well, their lordship knows that a court of one. He said, if I'm the only one, I'll always stick to this original intent. Court of one. So, well, absolutely. Your basic, so all that I'm saying is, one, because I've done the constitutional aspect, yes, unless your lordship anchors it in the values of 14, 15, 16, 19, 21, that's the
But
first
to
part.
put it really bluntly, is the relationship between a man and a woman
Yes,
so fundamental
yes,
to our law and therefore the Special Marriage Act
yes.
that for us to comprehend that it will also include a relationship between a same-sex couple would be completely redoing the tapestry of the legislation.
So this
If we
is, well,
say yes, then obviously we cannot
the
accept your
underlying
position.
agnostic
We-
thrust is the underlying agnostic thrust of SMA, antithetical to your lordship's recognizing what Article 14 normally will always include, namely same-sex persons enjoying the same importance and benefits of marriage as different sex persons. That's the long and short of it. As an aid to interpretation, I've only cited one case which says, and only interpreted statutory out of the Constitution. Does the underlying thrust, alternatively, an interpretation of SMA, prohibit or preclude your lordship from doing so? Or is your lordship's institutional capacity so compromised by a particular case that your lordships cannot do it? That's the fourfold way, connecting yesterday and today.
And really your argument is that, the institution of marriage in itself
Yes.
is so very important
Well,
that
to
to deny it to same-sex couples would be really contrary to fundamental constitutional values.
sorry to interrupt my Lord the Chief Justice, because my note yesterday, I said it, para 15 lists 7 important indicia of marriage, and the appendix
Correct.
lists more. Their counter says so. I rely on it heavily. The question is only exclusion. You have it for that side of the table, you don't have it decided. Para 15 of my submissions. My Lord was kind enough to note it down also by hand. I mean, you cannot have a system which applies uniformly to every category.
No, why?
Rape.
Why can't it apply to a homosexual couple?
No, with a caveat. Well, it's a criminal offense which has been defined. I will find the shortest definition is non-consensual penile vaginal penetration. It's one simple way of putting it. Now, of course, it has been expanded after the Verma committee to mean other forms of but otherwise non-consensual penile vaginal interface. Penetrative. Now, it is true that as well as rape, apparently rape is a crime even by a woman or a man in France, as far as I know. Those are special cases. Today, your lordship's issue is, can your lordship not move forward by these kind of possible obstructions?
And then we admit that in this case, it will apply to one kind of one kind of same-sex partner. This marriage offense,
yes,
it's a marriage offense, will apply to one kind of same-sex partner.
It is possible. I'm only saying it differently because it's a crime. According to me, it will be covered in a penetrative same-sex situation also.
No.
But it's a crime. A crime would have to be
we are talking of outside of the marriage relationship. When you indulge in that, that's a matrimonial offense, entitling the other spouse.
No, it will be only if a lordship holds this marriage. Lordship will have to hold this category of unions to be a marriage first.
That's right.
Then the question will arise.
Testing.
Yes.
We're testing that if
yes, correct.
Then it will apply to one class of same-sex
therefore,
relationships and not
there are
the
two
other.
ways. I mean, I concede there are two ways. One is that if your lordship holds this class to be covered, then your lordship would have 27 applying to penetrative assaults.
Then we have in this.
No, even for the same sex. Even for the same sex. That's the logical conclusion. Alternatively, your lordships could draw a line saying it's a criminal offense which has been defined in a heterosexual context. These are the two options. I can't say more.
Then we have 3 categories, really speaking. We accept the first option which you are offering, which is that A, it applies to